The Supreme Court just transformed American gun law forever, and most people missed what actually happened. An 8-1 decision rewrote the rules that every gun case will now be judged by. Stay until the end. Subscribe and hit like so this reaches everyone who needs to hear it. The case involved Zaki Rahimi, who got into an argument with his girlfriend in December 2019. When she tried to leave, he grabbed her, shoved her into his car so hard she hit her head on the dashboard, then fired at a bystander who witnessed it. A Texas court issued a protective order barring him from owning firearms. He signed it, acknowledged it, and completely ignored it. Over the next 2 months, he fired a gun in 5 separate incidents and showed up at his ex-girlfriend's house in the middle of the night. When police searched his home, they found 2 guns, ammunition, and a copy of the protective order sitting right there among it all. He was charged under 18 U.S.C. Section 922 G8, a federal law from 1994 that says if a court finds you are a credible physical threat to someone, you cannot possess a gun while that protective order is active. Rahimi claimed that law violated his Second Amendment rights. After the Supreme Court's 2022 Bruen ruling changed how gun laws get tested, researchers tracked more than 2,000 federal court challenges in just 2 years. Courts were striking down laws that had been on the books for decades because judges couldn't find a matching law from the 1700s. The Fifth Circuit ruled that the 30-year-old law protecting domestic violence victims was unconstitutional in 3 states. The legal protection keeping a court-verified abuser from owning a gun simply disappeared. On June 21, 2024, the Supreme Court ruled 8-1 in United States versus Rahimi, reversing the Fifth Circuit and upholding the federal law. This wasn't a close call. It was a near unanimous message that lower courts had been getting this wrong. Chief Justice John Roberts wrote the majority opinion. Joining him were every conservative, Alito, Gorsuch, Kavanaugh, Barrett, and every liberal, Sotomayor, Kagan, Jackson. 8 justices across every ideological line, all agreeing. The lone dissent was Justice Clarence Thomas, the same man who wrote the Bruen decision 2 years earlier. The person who created the very legal test that transformed gun law was the only one who believed that test should be applied even more strictly. Legal scholars at the University of Virginia analyzed more than 450 Second Amendment challenges filed after Bruen and found that more than 1 in 3 published appeals, court decisions concluded the challenged law was unconstitutional. After Bruen, the strike-down rate exploded. Different judges, different circuits, total legal chaos. The Rahimi ruling was the Supreme Court stepping in and saying enough. But buried inside Roberts' reasoning is one idea most people overlooked, and it rewrites the rulebook for every gun case that comes after. Roberts opened with one line every American should understand: the Second Amendment is not a law trapped in amber. The Constitution doesn't require today's laws to be identical copies from 1791. Founders wrote down principles, not a legal code for every situation that would ever exist. That single line was Roberts telling every federal judge to stop treating the Constitution like a museum piece. Roberts pointed to surety laws, which required people who threatened others to post a financial bond and temporarily lose weapon access, and going armed laws, which allowed courts to act against people using weapons to cause fear. Neither was identical to the modern domestic violence statute, but both showed the same underlying principle: people who pose a credible, court-verified threat can be temporarily disarmed. The law at the center of Rahimi had been protecting domestic violence victims for 30 years without serious constitutional challenge until Bruen created the opening. Research consistently found that the presence of a gun in a domestic violence situation increases the risk of homicide by 500%. By upholding this law, the court closed a legal gap that had briefly left millions without protection. Do you think the Supreme Court made the right call in Rahimi, or did they open a door that will eventually go too far? Drop your answer in the comments below. Justice Thomas's dissent isn't a fringe opinion. It's the most strict, most consistent pro-gun rights argument on the court. While everyone else moved forward, Thomas stood alone and said the majority crossed a line. Thomas argued his own Bruen test requires more precise application. The government failed to show any historical law genuinely similar enough to the modern statute to justify it. Surety laws didn't take your gun. They required a financial bond while you remained armed. The modern law prohibits possession entirely. After Bruen, gun rights groups filed 34 new lawsuits in the first 6 months alone, and another 34 in 2023. Thomas's argument is that the relevantly similar standard is too loose to protect ordinary gun owners from future restrictions dressed up in historical language. The two most important competing frameworks for Second Amendment law were written by the same man, one as the majority author, one as the only dissenter. The Second Amendment has been seriously interpreted by the Supreme Court only 3 times in modern history. Heller in 2008 gave you the individual right to keep a gun at home. Bruen in 2022 extended that right to public carry. And Rahimi clarified what historical tradition actually means, not a precise copy from 1791, but a principle the founding generation recognized. Before Rahimi, lower courts treated Bruen as requiring nearly identical laws from 1791. A federal judge in Mississippi struck down the federal machine gun ban because he couldn't find a precise 1791 equivalent. Roberts called that out directly. Apply Bruen that literally. And the Second Amendment would only protect muskets and sabers. The Trace built a database of more than 2,000 federal court decisions citing Bruen. In just 2 years, more than a third of published appeals court decisions concluded the challenged gun law was unconstitutional. Laws that existed without serious challenge for decades were being struck down because judges couldn't find matching 18th century statutes. The Rahimi framework was a direct response to that breakdown. This ruling quietly changed the legal landscape for red flag laws in more than 20 states. Red flag laws were never mentioned in the Rahimi opinion. The principle protecting them was placed at the very center of it. A federal law banning firearm possession by people under domestic violence protective orders was fully restored nationwide, including in Texas, Mississippi, and Louisiana, where the Fifth Circuit had wiped it out. The DOJ requested the Supreme Court apply the new Rahimi framework to 5 other pending cases. The court vacated those rulings and sent them back for reconsideration. Over 12 million Americans are victims of domestic abuse every year. When a firearm is accessible to an abuser, the risk of intimate partner homicide increases by 500%. Rahimi restored a safety net that an estimated 1 in 4 American women will need at some point. But the biggest downstream battle involves more than 26 million Americans with a felony conviction whose gun rights may be permanently stripped. 2 federal courts have already reached opposite conclusions since Rahimi. It's coming back to Washington. Do you think red flag laws are a legitimate use of the principle the court created in Rahimi, or does it go too far? Tell us in the comments below. The 2 most significant pending cases were Range versus Attorney General and Daniels versus United States. Both involved the federal felon in possession ban. The Third Circuit said that ban was unconstitutional as applied to Brian Range, whose only conviction was a 1995 food stamp fraud case. The Fifth Circuit reached a similar conclusion about a man with old, non-violent drug convictions. After Rahimi, the Supreme Court sent both back for reconsideration. Both courts applied the new standard and struck down the bans again anyway. This question is coming back to the Supreme Court. Over 8% of all U.S. adults have at least 1 felony conviction. That's more than 26 million people currently prohibited from owning a firearm. If the Supreme Court rules the felon in possession ban unconstitutional as applied to non-violent offenders, millions more Americans could legally own guns overnight. Justice Kavanaugh defended using post-ratification history from after 1791, including the Reconstruction era around 1868. If future courts accept that broader historical window, it opens more evidence that could cut either way on assault weapon bans. Gun control advocates called Rahimi a life-saving decision. Johns Hopkins experts said it reaffirmed policymakers' authority to disarm people who present verifiable threats. Domestic violence organizations cited research showing protective order prohibitions reduce intimate partner homicide. The NRA called the ruling narrow and explicitly not an endorsement of red flag laws. That message was aimed at gun owners. Don't read this as a setback. The Harvard Law Review noted that principle as a standard for Second Amendment analysis doesn't appear anywhere in Bruen. Rahimi introduced it. That single word changed the constitutional test for decades. Even liberal justices who dissented in Bruen joined the Rahimi majority because Roberts's interpretation is significantly less dangerous than Thomas's. Rahimi isn't the end, it's the opening chapter. The Supreme Court is building one case at a time as a complete constitutional doctrine that will shape American gun rights for the next generation. Most people won't realize how significant these decisions are until they're already living with the consequences. The three foundational rulings are now in place. Heller gave you the individual right to own a gun for self-defense at home. Bruen extended that right to public carry. Rahimi defined what historical tradition means in practice. Challenges to felon bans covering 26 million people, assault weapon bans in the 3 largest states, carry restrictions in dozens of cities, and red flag laws in 21 states are all moving through the courts right now. The real divide is between those who want Bruen applied as a strict rule-based system and those who want to interpret founding-era principles in light of modern circumstances. Thomas is firmly in the first group. Roberts, Kavanaugh, and Barrett are in the second. What do you think the Supreme Court should take up next? The felon ban, assault weapon bans, or red flag laws? Drop it in the comments right now. That's what this 8-1 decision really means for your Second Amendment rights. The biggest battles are still coming. If this helped you understand what's at stake, subscribe now. Hit like and drop your thoughts in the comments. Your voice matters more than you know.